Good afternoon, and welcome to today's event, Navigating the Capital Adequacy Rule, Legal and Policy Perspectives. My name is Stephen Schaefer, and I am the director of the Federalist Society's Regulatory Transparency Project. First, I want to welcome all of you to today's event, those of you who are in person, watching the live stream, and those of you who are going to listen or view this later. I also want to thank all of the panelists for participating today and sharing their expertise, as well as the Federal Society team, especially Sarah Bankson, who helped to plan this. I'm going to keep introductions short. This is an exceptionally accomplished panel, and if you want to see more about their many accomplishments, please check out fedsoc.org. That's fedsoc.org. First, we have the Honorable Eugene Scalia. He's a partner at Gibson Dunn, co-chair of the firm's Administrative Law and Regulatory Practice Group, a senior member of the firm's Labor and Employment Practice Group, and Financial Institutions Practice Group. He returned to Gibson Dunn after serving as the U.S. Secretary of Labor from September 2019 to January 2021. We're also pleased to have with us the Honorable Randall Quarles. He's chairman and co-founder of the Sinosure Group, a Utah-based investment firm. From October 2017 through October 2021, Mr. Quarles was vice chairman of the Federal Reserve System, serving as the system's first vice chairman of supervision. We are also happy to host Peter Conti Brown. He is the class of 1965 Associate Professor of Financial Regulation and an Associate Professor of Legal Studies and Business Ethics at the Wharton School of the University of Pennsylvania. As a financial historian and legal scholar, Professor Conti Brown studies central banking, financial regulation, and public finance with a particular focus on the history and policies of the U.S. Federal Reserve System. We're also honored to have with us Trent McCotter, who is a partner with Boyd & Gray, PLLC. He has an extensive appellate practice and has authored and submitted over 50 briefs at the U.S. Supreme Court. He previously served as Deputy Associate Attorney General, which oversaw DOJ's civil appellate and federal programs branches. And we are also pleased to have with us Jeremy Newell, who is a senior fellow at the Bank Policy Institute. He's an expert in banking law and financial services regulatory matters. He's a former partner at Covington & Burling. Today's conversation is on the multi-agency rule from the FDIC, the Federal Reserve, and the Office of the Comptroller of the Currency. The Capital Adequacy Rule is modeled after the Basel Committee on Banking Supervision, which comprises central banks and bank supervisors from 28 jurisdictions. This rule will substantially increase the capital that banks are required to hold. I'll turn it over to you, Gene. Thank you.
Steve, thank you. Pleasure to be with all of you today. I'll kick things off with short remarks. You'll hear from the panel. We'll have some discussion and questions among the panel, and then we'll save time at the end for questions from the audience. One of my most satisfying victories as a litigator was representing MetLife in challenging its designation as too big to fail by an agency called the Financial Stability Oversight Council. MetLife's designation meant that it now would be regulated like a bank. This was an important case to MetLife, and part of what made the win memorable for me was the personal impact the win had from the MetLife team that I'd worked with. In the hours immediately after the ruling, there was a cautious standoff between MetLife and the Fed bank examiners who had set up shop at MetLife since its designation. I believe there were about a dozen examiners. Then they'd been given office space at MetLife's offices. And once the ruling came down, MetLife immediately began asking when it could ask these folks to leave. Unexpectedly, the examiners emerged from a huddle in their offices to say sheepishly to the MetLife team, well, we guess we'll be leaving now. And they vacated that afternoon. I got an appreciative phone call later that day from MetLife's comptroller. She had just cleared her calendar of a nearly endless series of meetings with bank examiners. She was giddy in all her newfound free time. Well, the MetLife case was my introduction to bank regulation, which historically has been distinctive in a number of ways. As my story shows, bank regulation is unusually intrusive. At a major bank, examiners are on site daily. By way of comparison, an agency that I used to supervise, OSHA, estimates it would take its inspectors 170 years just to visit once every OSHA-regulated work site in the country. Bank regulation, or supervision, Peter, if that's a more appropriate term. Bank regulation also historically has been highly discretionary. In the examination process, examiners issue findings on what, in their judgment, are, quote, matters requiring attention, or requiring, quote, immediate attention by the bank's management or board. These notices operate as inviolate legal commands. Bank regulation, I should add, is distinctive too because the safety and soundness of banks is of immense national importance. The unique features of bank regulation that I've mentioned arise in part from historical experience and recognition of the sweeping consequences of bank failure for bank customers and potentially the economy at large. Because bank regulators are on site, exercise great discretion, and do so on matters of great consequence, banks historically have been highly deferential toward their prudential regulators. Suits against bank regulators are rare. But the new capital rules proposed last fall by the nation's banking regulators could test that proposition. And they raise interesting questions about our model for bank regulation as a whole. The proposed capital rules have generated much controversy. One study found that of the public comments filed on the proposal, 97% were negative. Asked about this at a congressional hearing, Fed Chair Jerome Powell said, "It's unlike anything I've seen." The chair also said, quote, "We do hear the concerns, and I do expect there will be broad and material changes to the proposal." Of particular relevance to this panel, the proposal has led to scrutiny of bank regulators' legal authority and the legal processes they follow. To a practitioner of administrative law, the capital rule proposal is unusual. To oversimplify, just slightly, much of the text of the rule itself is a collection of math equations for determining bank capital requirements. The preamble that precedes this rule text, the so-called proposing release, is principally a description of how those equations function. Ordinarily, the heart of a rulemaking proposal is a description of why the agency is adopting the specific regulatory parameters it is, how it arrived at them, and why they're right. Not so here. Now, perhaps that's partly because bank regulators are not accustomed to having to explain themselves to bank regulatees. It may also have to do with these rules' provenance. The rules, as Steve said, are meant to implement standards adopted by the Basel Committee on Banking Supervision, a body of bank regulators from 28 jurisdictions. The fact that a lot of the spade work for the recent proposal was done by the Basel Committee and its staff may be part of the reason the proposal itself is accompanied by less explanation and justification than an administrative law practitioner would expect. The last thing I'll note is the impact of the proposal. One professor estimates the proposal would result in approximately $180 billion in additional capital requirements for banks. Critics argue that a burden of that magnitude will radiate throughout the economy with significant adverse effects. These days, when a lawyer hears such things, thoughts turn naturally to the Supreme Court's major question doctrine and related questions. What is the statutory language that authorizes bank regulators to impose such requirements on banks and the economy at large? And is that statutory language delineated in a way that's consistent with our constitutional rights and constitutional structure? We couldn't have a better panel to explore these and other questions about the capital rules, so I will now turn it over to Randy Quarles.
Thanks. Well, for my opening remarks here, and I hope there's a robust discussion, but for my brief opening remarks, I wanted to begin with just some principles, basic principles we should keep in mind in thinking about any capital framework and about the changes to the capital framework that are part of the Basel III Endgame that the Fed has proposed that we're considering now. So, a few principles. The system needs a certain level of capital to ensure that it can withstand the slings and arrows of outrageous fortune, and because of the various collective support systems that we have in place for the banking industry, every bank and the industry as a whole has an incentive to shade their capital down. That's moral hazard. So it is appropriate for there to be a governmental requirement for a minimum level. And after the great financial crisis, that requirement was greatly increased. Second principle, it is possible to have too much capital for an efficient system. Outside of the universe from which various finance academics make their occasional visits to our planet, an increase in capital, while making the system safer with diminishing returns, also reduces its ability to provide credit with increasing effect. It is not true that if one pill is good and two pills are better, that swallowing the whole bottle is best. In addition to requiring a general minimum level of capital, it's appropriate for a capital framework to have elements that vary depending upon particular types of risk. More capital should be required against business loans than treasury securities. More capital should be required against a business that trades in treasury securities than against a static portfolio of them. Principle number 4, the banking system is one part, indeed a minority part, certainly in this country, of a broader integrated financial system. Measures taken to strengthen the banking system may weaken the overall financial system if they drive the riskiest activity out of the well-capitalized banks and into less capitalized and more fragile parts of the system. Principle 5, our financial system, in turn, is one part of an integrated global financial system, at least among the advanced financial economies. And measures taken to strengthen our system may backfire if they drive those risky activities into less well-capitalized foreign banks that are heavily interconnected with ours. A level playing field is not only fairer, it is safer. Principle 6, rules should be viewed holistically, together with supervisory practices and other regulations. And principle 7, financial system policy is an important part of overall monetary and economic policy, although too often they are treated separately. The reason that central banks should be heavily and integrally involved in banking policy is that it has very consequential broad effects throughout the economy. So, how does the Basel III Endgame look in light of these principles? First, I defend its implementation. It identifies, not how it's being implemented, lest there be, it identifies some appropriate risks for more targeted capital attention. Operational risk is trickier, they got it wrong. I'm expecting some of the other panelists to talk in detail about how, but I think it can be made workable. And it's part of an agreed international level playing field. That's good for us, it's good for everyone. The US proposal, however, is a big increase in the level of capital, 20 to 30% by many independent measures. That level of capital increase in the aggregate is unjustified. There are a lot of studies of the optimal level of capital. They all turn on essentially how big of a shock you think the system ought to be able to withstand. The Bank of England bases theirs on a shock the size of the great financial crisis. The Fed has a paper. It's not an official institutional position, but it's a defensible Fed paper. Bases theirs on 1.5 times the great financial crisis. The Minneapolis Fed bases theirs on many times, a shock many times the size of the great financial crisis, basically an asteroid hitting the Earth and ending life on the planet. The US system already had optimal levels of capital that were at the high end of the range to withstand another great financial crisis, and in the range, although at the low end, for 1.5 times the great financial crisis. It is not justified to increase that capital again by an additional 20 to 30%. Some have argued that the bank failures of last spring show that the system needs more capital. As the physicist Wolfgang Pauli said to a particularly dim student in his class, that answer is not right. That answer is so bad it isn't even wrong. The bank failures of last spring were the result of liquidity crises brought on by mismanagement and supervisory failures, not the capital rules. There is no amount of capital on earth that will allow a bank with $200 billion in deposits to withstand the withdrawal of 140 billion of them over the course of 2 days. Nothing in this capital rule would have changed the course of SVB by 1 iota. It is a pre-existing policy objective to greatly increase capital levels that is trying to piggyback on an unrelated policy problem. The proposal would create a very unlevel playing field, both between banks and non-banks and between US banks and foreign banks. As I noted above, this will drive activity out of the quite well-run, well-supervised, and well-regulated US banking system into the weaker parts of the system. As Talleyrand said, it is worse than a crime. It is a blunder. And finally, this is not the time. The Fed is trying to calibrate a slowing of inflation, which will necessarily involve a slowing of the economy. That looks, because it is taking so long, we've got a Wile E. Coyote effect that no one has yet looked down and realized they're over the canyon, that it will be discontinuous rather than gradual. Adding this large increase in capital levels at this moment risks disrupting the Fed's other processes. How am I doing on time?
You're good. So far?
So far. So then let me make one last comment about process. The Fed is a so-called independent agency. I'll leave it to others to comment on the constitutional appropriateness of such things. I'm a simple country lawyer, or I was a simple country lawyer. Now I am a PE executive, in the hierarchy of scorn of constitutional law scholars that is barely above real estate developer. But let us take as a given that the Fed is an independent agency. It is intentionally and quite significantly insulated from political pressure. Terms of 14 years, the operational arms of the system, the reserve banks aren't even governmental bodies. It is also a nonpartisan agency rather than a bipartisan agency like the SEC or many of those created in the New Deal. And I believe that all of that makes it appropriate for the Fed to follow processes that seek as much consensus as is possible in its actions. There are two sorts of approaches. One is to seek that consensus among all possible constituencies and then put forward proposals that will enjoy a fair bit of support within the agency and within the political process. The other is to put forward proposals and say, if you don't like it, vote no. This risks turning the Fed into a much more politicized agency and reducing support for its actions in general. We made a lot of changes to the regulatory system while I was at the Fed. All of those were heavily negotiated before any proposal went out. Across the political spectrum, they enjoyed strong bipartisan support. As an example, I still want, to recalibrate the G-SIB surcharge. The Fed said it would. Our calibration is unjustified. We haven't done anything about it. But it was clear that I did not have broad support for doing that on the board or on the Hill. Some support, maybe even majority support, but not strong, broad support. I could have put that recalibration proposal to the board and said, if you don't like it, vote no. But the political uproar would have been considerable. It would have damaged the Fed. It would have politicized everything else we were doing. This proposal clearly did not have broad support. We hear that it's being walked back to something more acceptable, but the process has damaged the Fed's reputation for impartiality, for analysis, and for fairness. And finally, the last issue, when I arrived at the Fed several years ago, there was a lot of advice to me to burn it all down. And I said, no, we're not going to do that. We will be measured. We will be analytical, we will build support for what it is that we're doing, and we will make a lot of change, and if we do it that way, it will last. If a proposal with respect to capital, such as the Fed has put forward, were to actually become final, then when the pendulum swings again, and my replacement is in charge, they will say, we tried it your way, and we're not going to do that anymore. And that will result in a much more unstable system that will be bad for everyone.
Terrific. Thanks. Peter.
Thanks so much, Gene, and to all of you. I have I'm going to organize my thoughts in a few different categories. I want to speak about capital adequacy in a measured defense of the proposal and process. And I want to approach this from the perspective of law, history, economics, politics, central banking, and the Marvel Cinematic Universe. Gene tells me I have 10 minutes, but I can play a little bit, so we'll see if we get through everything. Let me start actually with Marvel Cinematic Universe. I would like to meet the person who pronounced the proposal that we're debating, Basel Endgame, because I have a series of questions about why. I always thought it was a silly name. And then I started watching Thursday Night Football, and I saw that BPI definitely thinks that this will usher in the apocalypse. And so I thought Endgame, maybe it is appropriate for, at least for some people, on this. This idea that the rule itself has been politicized ab initio, I think, is a question that we should beg. I think the politicization might be, if I can summon Ronald Coase, not a function of the Fed. And so in response to Randy, the delegitimization that has occurred might be occurring in the reaction to this question. That leads me to the question about what is the nature of the politics of bank regulation, or especially of capital regulation. As I was listening to Randy's principles, I was nodding my head. I thought all of those principles made abundant sense. Now, he and I are not members of the same political party, but he and I would both consider, yet he says, exactly, I still have some work to do ahead of me to persuade him of the errors of his ways. But as I was listening to this, what I've long recognized in virtually every speech that I've heard Randy give, is expertise. He and I do share, and we speak a common language of technocracy and expertise. And we have, in that sense, the principles he announced. That's a very technocratic exercise. For those of you outside of banking, some of the things that he spoke about might feel a little technical, might feel a little remote, understanding exactly how we calculate these very equations that Gene mentioned, not to compliment. Randy and I would look at with great understanding. We understand what Tier 1 capital looks like, and we understand why it's very basic arithmetic to understand these things as ratios. The problem, though, with calculating capital adequacy, that question that we then flip from the principles that Randy announced, which I could send on in each one, to his implementation of them, where I didn't recognize much overlap with my views and his, were the fact that these occur, those judgment calls, these policy decisions occur after a technocratic consensus can no longer sustain policy decisions. Now, this is common in virtually every part of government and public policy. Technocrats come together, grapple together about what is the common sense, the common language, the common area where our expertise can inform policy. And then there is a gap between where technocratic consensus no longer obtains, where policy must still be made. Now, what should we fill that gap with? Well, one thing we might fill it with is a fealty to the Federal Reserve and say that there must be a point of view. That point of view is institutional. And the Federal Reserve should defend itself against all comers. And that's consistent with history. The Fed is one of the most powerful political actors in American history, at least in the 20th century, since its beginning. There are very few instances, including following periods of the Fed's own admission of error, where Congress has taken authority away from the Fed without giving it more authority again. I think from a perspective of political theory, I think that this is wanting. When I hear the idea expressed first by Chair Powell, then by Randy and others, that the election of 2020 should have no consequences, not really, that instead what we should have is a consensus that the governors of the Board of Governors owe something to each other, I ask myself, what kind of a political theory is that? When I think about the kinds of compromises I make with my wife, Nikki Conti Brown, I think, this is very important. We chose each other. We're invested in each other's future. When I think about the kinds of compromises I must make with my faculty colleagues, they chose me, I chose them who are junior to me. We are in a kind of symbiotic relationship where the governance is mutually constitutive. But Jay Powell did not choose Michael Barr. Joe Biden did. And the Americans chose Joe Biden, just as the Americans previously chose Donald Trump. It is thus not a surprise when we listen to Randy Quarles speak so eloquently about why he does not like this proposal, that he would not have initiated it. And that is good government. That is appropriate democratic theory. So that's my perspective on politics. Let me explain something on economics. It's an elaboration of what I just said. We hear in the criticism of capital adequacy, not just this rule, but going back many, many decades. There was a hearing in 1936 where the FDIC chair, then Leo Crowley, proposed what he called a dumb rule. He said that we need to have capital regulation such that for every $10 of deposits, there's going to be $1 of shareholders. So it's a 10% capital rule. And the banks absolutely hated that idea. All hell broke loose, and he was just trying to defend it. He's like, well, why is it 110 instead of 1 out of 100? And he was just like, I just think this is the good way to do it. And you can look in every single proposed capital regulation since it's been formalized in the United States since the 1970s, going back further and more recently. And that question, where is the inflection point? Where does the derivative become negative as opposed to positive in terms of building a resilient economy without having negative impacts on the macroeconomy? And you will hear the interests who want to see more benefits to their shareholders say it tilts toward less capital in this system, not more. And I don't fault the banks for doing that. I think I tip my hat to BPI, who launched what I would regard as one of the most significant and successful political campaigns in my memory, and apparently Jay Powell's too. They're doing their best for their own shareholders, but that doesn't necessarily mean that that's a pro-social position, even though it would be one that would benefit their own constituents. The question then becomes one of a kind of, if we want to be a little cynical, call it clairvoyance. And here I would put that the pin of clairvoyant on both Randy Quarles and his successor, Michael Barr, and all of those who have a clear vision that such and such amount of capital will definitely lead to recession, and such an amount of capital will certainly prevent a financial crisis. I call humbug on both. I think that that is not given to us to know. And that what instead, less cynically, I will say, rather than clairvoyance, what we're talking about here are value judgments. And if Randy can invoke Talleyrand, let me invoke Churchill and say, what a terrible way to make the value judgment about capital adequacy by hosting a democratic election. But I defy you to come up with something better. I can't think of one. Let me say a word then about history. I do have a stopwatch going, so I'm doing okay. Gene said he'd cut my mic and throw water at me if I go on too long. So, the history here, as we think about it, and this will lead to questions of constitutional law as well. I appreciated Gene's head nod toward a distinction between supervision and regulation, but I want to be really clear about this. These are incredibly different concepts and completely separate ideas. Here we're debating a regulation for sure, and so it's appropriate to think about it from the lens of the Administrative Procedure Act and hosting this as a conversation, a dialogue among administrative lawyers, I think is appropriate. But what this speaks to is a supervisory engagement whereby understanding what an appropriately capitalized or an adequately capitalized bank is, to use the statutory term, what a bank that is safe and sound is indeed a discretionary judgment. And it's the very thing that gives conservative administrative lawyers like Eugene Scalia stress hives to contemplate. And it has been with us since before the U.S. Constitution. The very first bank chartered in the Bank of North America, the charter given to William Morris, followed by the first Bank of the United States, the Bank of New York, charter given to Alexander Hamilton. All of these spoke to the common law authority elucidated by Blackstone of visitorial powers for the narrow charter that was granted by the government. These visitorial powers morphed, they changed, they evolved for sure, but the idea of testing the adequacy of shareholder commitment to banks whose failure would push costs onto government is at least as old as the U.S. Constitution. So if we want to, forgive me for being kind of a country Chestertonian, Burkean conservative, but some of the radical ideas being proposed that we should junk the system that has been around as long as the U.S. Constitution is the thing that makes me feel that stress instead. So for that reason, I think the constitutional claims, call it major question, concern, major questions doctrine or non-delegation doctrine, I just don't see it. This is much older than either of those two doctrines. And so I think any legal challenge here is going to have to come more in a statutory flavor. And let me then conclude by invoking G.K. Chesterton. Do conservatives still read him? I think they should. He's a very good philosopher and a theorist.
Absolutely.
This is a Chesterton fence, this norm against suits against bank supervisors, because bank supervisors and the banks co-own the residual risk that is a byproduct of a healthy and vibrant financial system. This fence that so many want to dismantle is serving a purpose. That purpose might be bad and we should dismantle it, but before you dismantle it, we should understand it first. And I haven't seen a lot of evidence that there's a lot of understanding behind what this unique and important set of institutions of bank supervision, including at its heart, capital adequacy, is performing.
Peter, thank you. And let me just comment, we are off to such a good start. We've had Churchill, Chesterton, Talleyrand, and a little Dickensian bah humbug. So, I don't mean to pressure Jeremy and Trent, but Jeremy, let me turn it to you.
Yes, I can say I can certainly promise that my comments will be devoid of this kind of erudition and much more replete with 65% risk weights and securities listing requirements, for better or for worse. So the Basel III Endgame proposal is a bit of a movable feast, and so one can take this in many directions. I think Randy did a nice job of describing why the questions that the proposal takes up in terms of do we have a capital framework that's appropriately risk sensitive are the right ones to ask. I think Randy also did a pretty good job of describing why the answers to the proposal provides to those questions are wrong. So I'm going to focus a little bit on, frankly, why I think the proposal reaches the wrong answers on a number of these questions, which is fundamentally a problem in the rule writing process itself. And so I'm going to focus, again, mainly on the administrative law issues. Before getting into that, I think, unfortunately, it is helpful to just get into a little bit of the brass tacks in terms of what the proposal actually does. Again, it concerns a cornerstone of bank regulation, which is our risk-based capital rules. They've been around in their current form for 40 years, and the concept is pretty simple, which is banks are required to maintain capital as a buffer against possible losses, and to do that, we assign a risk weight to all the various assets and exposures that a bank might have. And then we presumably base those risk weights on the relative riskiness of the assets. And then you apply those risk weights to a bank's balance sheet, you sum them up, and you get a risk-weighted asset number against which banks have to hold a particular percentage of capital. And what the proposal does is it completely overhauls the system of risk weights for large banks that we use in that framework. These are not modest tweaks. They touch every single aspect of the risk rating framework. And mathematically, those risk weights are crucial elements of calculating how much capital banks have to hold. If you have higher risk weights, you're going to have higher capital requirements. So two basic sort of grounding observations here. The first is just to underscore the magnitude of the proposal as an economic regulation. So it's recalculating the most important regulatory cost for $22 trillion in loans and other assets in the economy, and 80% of the banking system, right? So this is not some small, modest change to the margins of regulation. The second, and I think I largely agree with Peter on this, that this should be largely a technocratic exercise. The whole point of assigning risk weights is to identify the relative risk of an asset. And happily there we have a wealth of data and analysis on that point. We've got large databases of historical loss information about every risk stripe and every asset type, tons of studies and empirical research, call reports and other information that banks submit on a periodic basis to their regulators. And indeed, the Fed's got enough data on this point to build complex models that it uses every year in its stress tests to predict the performance of every asset on a large bank's balance sheet under stress. So one might reasonably expect that when overhauling the risk weights, that would have been premised on a careful review and study by the agencies of the data and evidence we actually have about risk. And the basic problem with the proposal is that it doesn't do any such thing, right? Its risk weights are not based on a careful study of the available data, but again, look something closer to assigning risk weights by regulatory fiat. And so I certainly agree with Peter that there is in bank regulation a jumping off point where you leave technocratic expertise and get to finer policy judgments, but this proposal doesn't even reach that jumping off point. If you sort of take a step back and again think about the requirements of the APA, again, which provide safeguards that are intended to protect against exactly the kind of approach I think you see in the proposal, right? You can debate the outer limits of the APA, but I think the basic principles are clear. Agencies have to make available to the public the data and the analysis on which their policies are based, and they've got to provide a clear and complete explanation of their choices. They have to consider all important aspects of the relevant policy problem, consider obvious and plausible alternatives, and consider at least to some extent the cost and benefits of their choices. So in short, the APA requires that agencies do their homework and show their work. And I just think that the proposal falls well short of that bar and frankly needs to be reproposed if it's going to be put on anything like a proper legal footing under the APA. If I were to tick through every aspect of the proposal that isn't consistent with the APA, we would be here for a very long time, so I'm just going to hit a couple of the highlights. So the first I've already alluded to, which again is that over and over again the proposal assigns risk weights to various assets and activities without providing any kind of empirical support or explanation for its choice, and without considering an entire universe of data that is often relevant. There are also cases where the proposal refers to data that appears that the agencies based their decision on, but the agencies don't actually provide that data, which is its own problem under the APA. I'm just going to give you a couple of the most egregious examples, and I warn you this will be very technical and wonky. The first is something often referred to as the securities listing requirement. So to assign risk weights for business loans, the proposal adopts two different risk weights. There is a preferential 65% risk weight that applies to loans to businesses where the bank is satisfied that the borrower is investment grade and that the borrower issues public securities. And for all other business loans, including loans to any business that doesn't issue public securities, which is to say every small business in America, it assigns a much higher punitive 100% risk weight. So a very significant difference. The stakes here are large. We're talking again about trillions of dollars of business loans that we're assigning risk weights to. Tons of data, fortunately, about the relative risks of different commercial borrowers. Does the proposal engage with any of that data? Not at all. In fact, the punitive treatment of loans to companies that don't have public securities is based on a single conclusory assertion in a single sentence in a 300-page proposal that simply says, well, companies that issue public securities are subject to public disclosure requirements, and therefore they're probably less risky. Again, that kind of policy choice made with no support and an ignorance of all available data is definitionally arbitrary and capricious, to use the APA language. Another example is the proposal's new framework for operational risk. So simply put, operational risk is the risk of loss because a bank makes a mistake somewhere operationally. Again, lots of available historical data on different types of historical operational risk losses at different banks related to different activities. You can go through the 300 pages of the proposal. There's not a discussion of that data at all. Instead, it invents an entirely new methodology that bases operational risk capital charges on the overall volume of a bank's business, measured by a bunch of different financial statement proxies of income and expenses. And that new science of operational risk, again, supported by just a few brief conclusory assertions in a few sentences that banks with more activities are likely to have more operational risk. Here again, the stakes are high. I think under the proposal, the operational risk capital charge is something like 10 to 15% of total capital requirements for large banks. And again, based on a methodology for which no empirical support is offered, notwithstanding the fact that there's a lot of available empirical data. So I would say that, again, is definitionally arbitrary and capricious, to use the language of the APA. Maybe the last point that I'll touch on, because again, there certainly is a long laundry list, is the proposal's failure to engage in any kind of meaningful assessment of the costs and benefits of the proposal. Again, we're talking about changing the principal regulatory costs of $22 trillion of loans and capital markets activity. And in the 300-plus page proposal, there is less than 2 pages that discuss the potential costs and benefits of those changes, and no attempt on the administrative record whatsoever to quantify any of those costs and benefits. Again, I think, you can have an interesting debate in terms of exactly what kind of cost-benefit analysis the APA requires, but I don't think this is even remotely a close question. 1.5 pages of non-analysis of an economic regulation impacting $22 trillion worth of loans and capital market activities seems something reasonably short of what the APA requires. I think I will leave it there. Again, then to underscore, I even want to separate this from the conversation and debate around the actual answers that the proposal lands on, which again, I think in many cases are wrong because the process itself has been so flawed. And underscore again, just from my own perspective, that the only way to address these kind of fundamental deficiencies from an APA perspective is to issue a reproposal that, again, puts the rulemaking on a much firmer legal footing under the APA.
Jeremy, thank you. Let me turn it to Trent, who is a litigator, a specialist in administrative law, and also is the co-author of a paper regarding whether the capital rules proposal and the statute under which it was issued present a question under the non-delegation doctrine. So that's a paper I commend to you. I think Trent will touch on, but I wanted to add that to the introduction of Trent.
Thanks, Gene, and thanks to Steve and Sarah for organizing this. As Gene mentioned, my practice focuses on regulatory litigation. If you're not a lawyer, that means that we generally sue federal agencies. And it's not a FedSoc panel unless somebody talks about non-delegation doctrine, so here I am. As Gene mentioned, I co-authored a paper on this capital adequacy rule and non-delegation challenges. It's with Rob Henneke at Texas Public Policy Foundation. I'm going to speak about the litigation environment that the rule would face if it were to go final, looking something like the proposal. Gene alluded to the unusual level of opposition to the rule, to the proposed rule. I believe the FDIC vice chair issued a statement against it. One of the Fed governors issued a statement against it. That opposition, in my view, is a harbinger of the headwinds the rule would face in litigation. So let me set the table. Courts are scrutinizing big regulations more now than ever before. If anything, I'd argue the bigger the reg, the more scrutiny it's getting, which is probably the opposite of how it used to be. You can look at a lot of examples. The Biden loan forgiveness rule that the Department of Education issued, that the Supreme Court invalidated, EPA CO2 regs and West Virginia v. EPA. And this isn't a rule particularly, but the fact that in a few months we might not have Chevron deference anymore is another indication of how courts are reviewing questions of administrative law. And financial regs are no exception. Gene mentioned a few that he's litigated. He and I are, for full disclosure, litigating against the SEC and their climate disclosure rule right now. The SEC voluntarily stayed that rule, and I can only guess, but I imagine part of the reason is that they were worried that a court was going to issue an opinion against them even before the litigation really gets going full steam. The SEC's had other regulations that have been invalidated recently on cost-benefit analysis, the kind of thing that usually courts don't even look at. Jeremy talked about some of the kind of arbitrary and capricious type arguments, so I'll focus on ones that are more like kill shot arguments. They're really high-level constitutional type arguments. And as Gene mentioned, I see two. In this case, they're really flip sides of the same coin. Major questions doctrine, non-delegation. Major question, in my view, is kind of like an avoidance doctrine. Easier to say that the agency just doesn't have statutory power than to say that they do, but the power is so broad that it's actually unconstitutional. So I'm going to focus on non-delegation because I think it's an issue that these banking agencies are probably not thinking very much about, although they should, because I did submit our white paper as a comment to them against the rule. And I think a lot of them, to be fair, view non-delegation arguments kind of like Peter did, which is, look, under current doctrine, like non-delegation is largely a punchline. That's what Judge Newsom in the 11th Circuit recently said in a separate opinion. And maybe that's true, but we also know from Justice Gorsuch's dissent in Gundy and from some subsequent opinions issued by other justices that there are at least 5, maybe 6 votes on the Supreme Court to reinvigorate non-delegation. I think it's just a matter of when and what the test will look like. And Justice Gorsuch's dissent in Gundy had a line that I think describes pretty well what's going on with this rule. He said, Congress cannot announce vague aspirations and then assign others the responsibility of adopting legislation to realize those goals. So what statutory limits do the banking agencies have here? What's their statutory authority? The primary statute, 12 U.S.C. 3907, for anyone who wants to look it up, says that the agency shall cause banking institutions to maintain, quote, adequate capital. Adequate. You ask how much capital you need, they'll say adequate. That's all Congress gave. And there's a lot of room for interpretation there. Obviously, it reminds me a little bit of Rolls-Royce, the car company. When people used to ask them how many horsepower their cars had, they would refuse to give you a number, and instead they would just say that it has adequate horsepower. And it was seen as kind of showing off if you were more specific than that. I don't think that's going to fly, though, with a federal court in the event that the Supreme Court has reinvigorated the non-delegation doctrine. The word adequate doesn't set a ceiling, it's not a formula, it's not a rate. As far as I can tell, there's no kind of historical term, adequate, that's kind of Congress was just readopting some technical term that everyone knew what that meant. So it's a pretty wide scope. And as others have already explained much better than I can, this isn't some minor reg either. This is regulating a core part of the economy. And it's also making a kind of policy decision, a core legislative decision. How much risk is society willing to tolerate? And you might be thinking, well, surely there must be something else in the statute to give the agencies guidance, right? And in a way there is, but I think it actually makes it worse. The very next sentence says that when determining what's adequate, the agencies can use such methods as they deem appropriate. So not only do they get to decide what's adequate, but they then get to decide the factors that go into deciding what adequate means in the first place. In our paper that Rob and I wrote, we call that a multi-layer delegation. You could call it kind of daisy chaining power. It reminds me a little bit of the Chief Justice's opinion in Free Enterprise against Peekaboo, the Public Company Accounting and Oversight Board. That was about removal protections for federal officials, but he had a line in there saying, look, we've had opinions where we allowed 1 layer of removal protections. We've allowed agencies to have that kind of flexibility. We're not going to talk about that now, but we'll say that this one involves 2 layers, and he has a line where he says that extra layer makes a difference. And in a way, it's kind of just ipsa dixit. It's just a statement, but it's a statement in a Supreme Court opinion, and it also allows them to draw a very clear line as to where they're going to allow challenges and where they won't. And I think if the Supreme Court wanted to take a real first step to reinvigorate non-delegation, this sort of statute is one that's ripe for challenge because of that multi-layer delegation. Relatively rare for agencies to have that kind of power, both a broad power in the first place and then a broad power to redefine it. So it's not so much of a leap, I think, if the Supreme Court reinvigorates non-delegation, that this kind of reg is one that could be in their crosshairs. And you're probably thinking, so like, what now? Like, we expect Congress to issue like new statutes that lay out more specific things? Like, that's a ridiculous proposition. They've never done that, except actually they have. And in fact, that was the historical trend. Going back to at least the National Bank Act of 1864, Congress set specific dollar amounts for particular banks based on the population of the city in which the bank was located. It's really only more in modern times that Congress has gotten away from that. The statute I've been citing, that uses just the word adequate, is from 1991. This isn't one of the old 1930s New Deal type statutes. So let's think, what's the world look like, though, if there is no real cabin on the banking agency's power here? Without those meaningful limits, banking agencies can start factoring in pretty much anything they want. And remember, they're going to cite the statute that says, apparently, that they can do that. the whole of government approach that we hear a lot about, where agencies are kind of going outside their lane on things, or at least they seem to be outside their lane, is going to be implemented through that, I would imagine. You're going to have the banking agencies say whether capital is adequate will now turn on things like DEI. How much has the bank implemented DEI policies? How much have they divested from investments they view as being bad for climate change? Anything like that. And the agencies will cite to their statutory power and say, hey, Congress wanted us to consider anything we thought appropriate. We think it's appropriate. So I think, sure, that Judge Newsom is right that the modern non-delegation doctrine is kind of a punchline. I think the banking agencies might look at it and think, oh, we got that in the bag, like non-delegation, everyone loses on that, like what a joke, right? But they should take it more seriously because of the risk that the landscape is really going to change. And the agencies face a risk with this too. Think to some of the more recent litigation, not involving necessarily non-delegation, but major questions, where agencies or even the president directly really pushed the limit. They pushed the limit of their power, and they ended up not just losing that case, but they ended up losing prospectively lots of other cases. A good example would be President Biden's vaccine mandate for contractors. It had long been understood that the president had pretty broad power to regulate the terms of federal contractors, except when he finally pushed it here, several circuits, and the Sixth Circuit in particular, issued a decision saying, actually, now that we reread that statute, we're not so sure the president has any power at all here. He's been citing a prefatory clause, and courts have kind of just gone along with it. So he didn't just lose that case, but he possibly lost the next 10 cases, the next 10 things that he wanted to do through contractors. And that's always the risk when these agencies push their power too far. And one final point, those who are in the area of regulatory litigation probably get kind of tired of everyone raising major questions doctrine and non-delegation doctrine. My joke, adopting Justice Scalia's line, is that it seems that every regulation is now an elephant and every statute is a mouse hole. But I think there's a reason for this. There's a reason people keep raising these challenges now, which is that broad, vague statutes tend to breed bad regulations, and people challenge bad regulations, and they'll use the options they have at hand. And so I speak more to the constitutional points than the policy points, but I think there's a lot of recognition that one of the reasons why, perhaps, this proposed rule seems so bad policy-wise is because the agency has such a free hand under the regulatory statutes. Thanks.
Terrific. Trent, thank you. This is heavy stuff, and I'm going to exercise a moderator's prerogative, take a brief detour, because the best thing I can offer when I speak to a Federal Society gathering is memories of my father, Justice Scalia, when relevant. Same when I talk to groups of lawyers. So Peter's question about Chesterton brought to mind a memory, which I'll just quickly share. It was my father's dramatic reading after dinner and a couple of drinks of a series of renditions of the poem Old King Cole. Old King Cole was a merry old soul, and a merry old soul was he. He called for his pipe, and he called for his bowl, and he called for his fiddlers three. That's the poem. Chesterton gives us versions by Alfred Lord Tennyson, Yeats, and Whitman in their style. And my father, after dinner, he loved it. He loved Chesterton. He read this one night. I'll just give you a little feel for it. Whitman, me clairvoyant, me conscious of you, old camarado, me piercing 2,000 years with eye naked and not ashamed. I perceive that you drink. I am drinking with you. I am as drunk as you are. I see you are inhaling tobacco, puffing, smoking, spitting. I do not object to your spitting. I'll stop there. In any event, wonderful memory of my father. For those who knew him can envision it. Why don't we take just a couple of minutes a person to maybe comment on what the others had to say, and then I've certainly got questions for you all. I know that members of the audience do too. Starting with Randy.
So let me just take 2 points out of a lot that has been provided, or maybe 3. That sounds kind of biblical. So one, on the politicization of the Fed as a result of process. I don't think Peter's view is crazy at all to think that sort of having votes and transparency, more transparency around the discussions that lead to outcomes in an agency like the Fed. I don't think that's a defensible view. I just think that it's wrong in the particular case. I do think that when you have an agency that has the insulation of the Fed, and it could be particularly appropriate for agencies that are structured like the SEC, where you have politics are expressly considered in the appointment of the people who are making the decision. But I think when you have an agency that is structured to be nonpartisan and is structured to be so distant from democratic control, that kind of, if you don't like it, vote no approach definitely runs the risk of undermining the support for that agency's actions, because if you don't like the politics that you're seeing, you don't have a way to contain it. So I think that's a practical problem. On the APA question, I think that the APA, I think that the fact of APA deficiencies is important. I think it should be viewed as important by the regulated entities. And by which I mean, let's hypothesize that, sort of as we're hearing, the Fed is in the process of walking back the capital proposal so that it comes to something that is acceptable. I don't think that I don't think that folks should declare no harm, no foul then at that point, because the proposal was put forward without sufficient input. We can't, and I say that out of my very high desire to maintain the ability of the Fed to operate, as it has for much of its existence. If we can't count on the fact that the agencies will comply with the rules that we put in place to ensure that their actions have broad political support and are informed by all the information that's available to them, then ultimately that will erode the support for the good things that those agencies do. And so I think that if there is not a sufficiently articulated reproposal of the rule, I don't think that people should say, well, no harm, no foul, if the substance has been made, even if the substance has been made significantly better. And finally, on non-delegation versus major questions, I guess my point there would be, I'm actually kind of a fan of the non-delegation doctrine, but I'm a private equity guy, so what does that matter? But I don't think we have to get there, because anything like this that the banking agencies are doing is obviously a major question that has dramatic consequences across the economy. And so you don't have to get to the farther issue of non-delegation to say that there probably is a constitutional issue here with regard to major questions.
Terrific. Peter, want to take a couple minutes?
Yeah. So I heard from Randy and from many others this idea that this independent Fed is just a kind of a vital part of a good functioning society, and central bank independence is heralded as this really important exception to democratic accountability. Let me go ahead and stipulate that that's true, but to the extent that that's true, that refers to the well-ordered concern that people have about politicians monkeying about with the money supply, the so-called time consistency problem. So as an independent monetary policy body, I think I would be about 2/3 of the way with you on that, Randy. I say 2/3 because I think that even that theory has real democratic deficits to it. It just has absolutely no application to bank regulation, which is, of course, highly politically inflected. There's no far-reaching judgment of the oarsmen from the Odyssey with beeswax in their ears taking us to the destination of capital adequacy free of the siren call. That's the stuff of technocrats, and then pushing forward thereafter. I'll tell you, Jeremy, if the APA said what you said it says, then I would agree with you 100%. But anytime you hear lawyers bandying about adverbs like definitionally, your eyebrows should go up. Also, Randy, when you say, obviously, this is a constitutional error, I think the same problem. Be wary of lawyers with adverbs.
I should have said certainly.
There's no cost-benefit requirement in the statute, unlike other statutes. Arbitrary and capricious is indeed an APA term, but there is no requirement in the APA that the Fed must show its work. That comes from one line of cases from the D.C. Circuit. Never been applied to this context, hasn't been applied to many others, so I'm dubious. So this is an assertion of what the law should be, but not a reading of the statute as it is. Then finally, on the constitutional questions, I'm not one to mock non-delegation or a major question. Your history is not correct. The 1863 and 64 statutes introduced the terms safe and sound. The comptroller was to ensure the safety and soundness of these entities, and capital adequacy, although not in that term, was definitely a part of this. So I think in the context of banking, what we have here is quite different. And I will conclude only by invoking Wittgenstein. And I think that there are some atomic principles here that are relevant. It is so clear that banks do not like this, and many others do not like this rule. The difference between not liking a rule and claiming it is illegal, and then still further claiming it is unconstitutional, those differences should be discontinuities in my view. And I think they're continuous in this debate, and I think that's a problem. You can have policy differences here, but to invoke illegality, you got to bring the receipts. To invoke that this violates our Constitution when this has been with us since 1789, the constitutional term for that is liquidated. I think that meaning has been liquidated.
Thank you. Jeremy.
Sure, thanks, Gene. So maybe just a couple of quick points. So certainly on arbitrary and capricious, listen, I think making a policy choice and having no reason or explanation for that choice whatsoever, certainly to me is the definition of the term arbitrary. With respect to cost-benefit analysis, and this is what I did try to cabin my remarks a little bit. Certainly, there's no requirement in the banking law that looks at anything precisely like what are in the securities laws in terms of a very strict cost-benefit analysis. On the other hand, I think the jurisprudence is relatively clear that part of the arbitrary and capricious analysis looks to whether there is some assessment of the cost and benefits of an agency's policy choices. So we'll just leave that at that. Second, since you raised the Marvel Cinematic Universe, I think we offer this, we owe it to this group an explanation of why we're all using the ridiculously silly phrase Basel III Endgame. There's a historical explanation for that, which is that the Basel Committee completely overhauled capital requirements in 2009 and 2010, and then about a year later decided that they want to make a whole host of other changes, but did not want to concede that in fact was Basel IV just a few years after Basel III, and so the language everyone invented to cover that up was first the finalization of Basel III and then Basel III Endgame. But if I had my druthers, we'd just call it Basel IV. One of the great ironies is the actual point of that Basel III Endgame exercise was to retain a crucial part of the bank capital framework where banks are permitted to use their own internal credit models to model credit risk, but to provide some guardrails around the use of internal models to deal with concerns in excessive volatility in capital requirements. That really, at the core, was the whole point of the Basel III Endgame exercise. As it turns out, the U.S., in issuing their proposal, they got rid of the use of internal credit models without even acknowledging that they had been party to a whole negotiated Basel to come up with a very plausible alternative, which again is its own separate problem. Lastly, there's been a lot of very interesting commentary here around the boundaries between supervision and regulation and precisely where this rule fits in, and I'm glad it came up. I mean, I think, as Peter notes, this is not supervision at all. This is an exercise in writing bright line legislative rules under statutes that the banking agencies administer. And I think in that regard, it's very clear that the APA's procedural and substantive safeguards apply, and that the banking agencies shouldn't be acting by fiat. But I do think Peter hits at a deeper tension in terms of this contrast between supervision and bank regulation. I think one thing that's been true over the past decade and a half or so is a lot of things that, frankly, traditionally were left purely to the supervisory process have increasingly become the subject of bright-line legislative rules, whether that's more detailed capital requirements, liquidity requirements, and so on. And I personally think on net that is a good thing. These are incredibly important policy choices, so I appreciate that they're made in the light of day, and ideally on the basis of evidence and data that the public has an opportunity to view and to provide views on, again, with a view towards getting it right. I think certainly one of the issues with this proposal and other proposals that we could talk about is it does appear that the banking agencies often approach decision-making under these rules sort of using the lens of supervision, which is an area where they view themselves as having very wide latitude to pretty much make whatever decision they see fit with no real burden of public transparency or accountability. And so certainly to me, that sort of supervisory decision by fiat approach is something that I see inflected in the proposal and the way that it completely overhauls risk weights without, again, any discussion of the actual data and evidence that's available on the risk of various assets. And certainly I think is probably part of a increasing trend that is worrying.
Well, Jeremy, thank you. And Trent, you had last word once. Why don't you take one quick last word, and then I've got some questions for y'all.
All right, thanks, Gene. Peter mentioned kind of historical terminology that's been used here, and the statute currently uses the word adequate, and it sounds like perhaps there isn't a historical pedigree for that word, but I think his point is that there are similar terms that have been used. And I think my response would be, even if that's true, and I don't doubt him that it is, that those terms don't really have an accepted meaning that clearly delineates agency power. And clearly delineating agency power is actually the current non-delegation test. So if the Supreme Court were to reinvigorate it, it would require something even beyond that. And the other thing I would say is that if terms like safe and sound were considered sufficient and detailed enough, then I wonder why Congress felt the need to include specific dollar amounts in the National Bank Act of 1864. Maybe they were just being safe, but the point is kind of broad terms like that probably wouldn't be enough in our view if the Supreme Court has reinvigorated the non-delegation doctrine. Thanks, Gene.
Terrific. Let me throw out, it's maybe a package of questions, but looking forward, and different panel members can take shots at this, but will this be reproposed before finalized? Will there be a reproposal? Will we see a reproposal this year, and if so, doesn't that mean there's no way we see a final rule this year? And then my last kind of process question is, could a final rule be approved over the vote of the chair? And do we think there's any prospect that would actually be done? Randy, do you want to maybe take the first shot at that, or do you want to punt to Peter?
Well, let me take the second question first. And I guess it depends on what the meaning of could is. So it's absolutely possible for the final rule to be approved over the chair's objection. The chair is one vote on a board of 7 people. The Federal Reserve Act gives him the task of being the active executive authority of the Fed, but no special policy role. And in the early days of that structure, after the Fed was restructured in 1935, the chair would even bring to the full board things like approval of the letter that he was sending to the dictaphone company to sign the dictaphone contract. So definitely the rule could be approved over the negative vote of the chair. Would it be? I think that would be very unlikely. The Fed operates under an ethos where the chair, I think appropriately, has a great deal of influence over those decisions. I don't think you would have a majority of the board vote against the chair if the chair weren't happy with the proposal. And then the first question was?
Whether you think this will be reproposed,
Oh,
or whether instead do we think
reproposed?
that they would go directly to a final rule based on the comments received?
Well, I don't see how the rule can be. I don't see how the rule can be sufficiently adjusted to be acceptable without it requiring reproposal under the Administrative Procedure Act. Now, does that mean that it would be reproposed, or would they try to do something where they'd say, well, some portions of this we're going to go final on, and other portions we will repropose? I think that's for a rule like these capital rules that have to be considered in toto, and given the level of deficiency of analysis that there was in the original rule proposal, again, I don't think that would be satisfactory. I don't think it would be the right thing for them to do, to repropose part and go final on part. I think you have to look at the whole, so they should repropose the whole thing. Would that mean that as a practical matter, I think there's still time if the Fed did this promptly. I think that it could get the rule final before the end of the year, but that would be moving extremely fast, and in just a few weeks, I think it would be, as a practical matter, too late for it to be final at the end of the year if they do repropose it.
Yeah, I mean, this is a dilemma that we're seeing in a number of agencies that proposed things that were really pretty big and controversial. The agencies then saw a need perhaps to dial it back, but in the fourth year of a presidential term, there's a race against the clock. It gets harder to repropose even when, as a matter of putting out a legally defensible rule, that's the right course. And so I think this is one rulemaking where policymakers will wrestle with that question. I think the SEC has been wrestling with it and sometimes getting it wrong. Federal Trade Commission has that on its non-compete rule. In any event, it's a question for a number of agencies now. Any other comments on that question?
I think the only thing I would say, and I feel a little bit funny saying this next to the first occupant of the vice chair for supervision, but in 2010, Congress looked at the Fed and found it wanting. It looked at its governance and thought, we have got this wrong. And so it created the post that for secret reasons, I think even to him, President Obama never filled. President Trump was the first to do so, and he did it with Randy Quarles. This chair-centric approach to the Fed has not been consistent throughout its history. We've had a couple of exceptions. It's been pretty stable. But what I think Randy Quarles and the Vice Chair for Supervision showed us is that that idea of the Fed chair leading on regulation and supervision, it should have ended in 2010. I think it did, mostly for the Trump administration. Perhaps it didn't by personnel overlap between Jay Powell and Randy Quarles and worldview. But I think that should be over. I think that we should be calling Chair Powell, Governor Powell, with respect to these votes, and the real leadership, the locus of leadership, shouldn't be on him, but should be on the Vice Chair for Supervision. And I want to be, just to be very fair, and Randy knows this, I said that during the Trump administration and had to duck as all of my liberal friends threw shoes at me when I made that case. I think it's a case to be made no matter who the president is.
He did say that. He did say he wished that somebody else was the Vice Chair for Supervision.
I did, yeah. But that caveat aside, I defended you.
Jeremy, Trent, I don't know if you have anything you want to add on those questions. I mentioned Basel III. Obviously, the capital rules are intended, roughly speaking, to implement the Basel III so-called Endgame. As we look toward the possibility of litigation, is the Fed's ability to say, well, look, we're relying on Basel III. This is a respected international accord. Is the way Basel III has been used here, Jeremy and Trent, in your minds, is it a strength? Is it a weakness if we end up in litigation?
I would probably view it as a weakness because I would assume any challenge to a final rule will be brought in front of a court that's probably generally skeptical towards agencies as a kind of a general matter. And then when you say that actually this isn't even coming from an American agency, it's really coming originally from kind of a like hoi poi meeting in the Swiss Alps or something, that's just going to be a bad optics point. I don't know whether it would have a legal consequence, Gene, but that's kind of my initial take on it.
Yeah, I think from my perspective, Gene, and I mean, on this point, I think it's always important just to start by being clear that I think international standard setting can be quite helpful in certain cases in bank regulation, especially where they help construct a level playing field for global banks that are competing across the world. So I don't think that sort of the Basel standard setting process is problematic per se in any particular way. But I do think that the way that the agencies have approached implementation of the Basel Agreement here is troubling for a couple of different reasons. In particular, there are large parts of the rules that seem to really effectively incorporate by reference and defer to choices that were made at the Basel Committee in 2018 and 19 without any kind of independent U.S. explanation or analysis. And indeed, I think that probably explains a number of the parts of the proposal where there's a very detailed, hyper-specific proposal that's put on the table without any explanation as to why the agencies chose that particular approach. I think probably in most cases the answer is because that's where the Basel Committee landed, and effectively they have a soft commitment to implement Basel standards faithfully. And in fact, the couple of egregious examples that I gave, the securities listing requirement and operational risk, are exactly cases of that. But again, of course, the Basel Committee is not a treaty. It's not legally binding. And again, it doesn't relieve the agencies of their independent duties under the APA to conduct a reasoned U.S. agency rulemaking. The other thing that's a little bit odd is even the treatment of the Basel Agreement in the proposal is very inconsistent. In certain places, again, it seems to rely pretty much wholly on the Basel standard. In other places, it decides to deviate from the Basel standard and impose a more stringent standard. Again, it doesn't, when it does that, have an explanation. Well, here's why we think the Basel Committee got it right in this particular case and why we got the Basel Committee wrong in that particular case. It certainly has much more the appearance of having cherry-picked Basel and the Basel standards with a view to crafting a proposal that has the end result of significantly raising capital requirements, which is something that a faithful implementation of the Basel standard would not have done. And again, in that process, there's just no explanation of why they've agreed with Basel in some places and disagreed with others, which certainly, I think is a legal deficiency.
Yeah, that does seem like a challenge that the agencies would face in litigation. I will say, when I litigated the MetLife designation, it's clear that what had happened was that U.S. regulators had pre-agreed before the Financial Stability Board that MetLife and certain other insurers would be designated too big to fail, and they viewed their job as now coming back to U.S. and just implementing that agreement. I think they were insufficiently attentive to their obligations under the applicable U.S. law. It created problems for them. I think the regulators here will have to be mindful of that. Randy, I think you were about to make a comment.
Oh, I was just going to say, on this issue of the FSB and the Basel Committee and the IMF, so these international, particularly financial organizations, I'm a bit of a heretic from folks who generally wear my political jersey. The U.S. in those organizations still has enormous influence, and generally, if we're unhappy with what comes out of the Basel Committee or the IMF or the FSB, is because we're unhappy. We would be unhappy if we knew what the U.S. had taken into the committee, and so the U.S. generally gets its way, and therefore these are force multipliers for us in getting our policy objectives. Now, folks in this room, myself included, may disagree with what some of the policy objectives were at the time that some of these decisions were being made. But there I think I'm very much aligned with Jeremy, that what I find distressing about some of the deficiencies in this proposal is that it will run the risk of further discrediting those processes if in litigation it's determined that, well, there wasn't any independent analysis of these. The idea of those international agreements is that they will then be implemented and justified in whatever way is appropriate domestically. And almost never is it the case that the U.S. has gone in and been snookered by the wily Europeans and has to come back and implement something we don't want to do. We just ignore it if that's the case. And so I am troubled, but on a slightly different level, because I think that the way it was done means that the Basel connection will be a litigation deficiency and therefore will further discredit what actually are sort of entities that are in the interest of the U.S.
Well, thank you. Well, we have a few minutes left, time for questions. Looks like we've got mics for people that do have questions. If you could keep your question as a question and keep it brief, we'll have the opportunity to hear more of them.
Thank you very much. I have a relatively simple question for the panel. To what extent do you believe that the FDIC's risk-based deposit insurance premiums have played any meaningful role, particularly in terms of deterring what I will call drunk driving banking, i.e. bankers taking risks that they have underpriced and therefore should be reflected in their deposit insurance premiums they pay?
I can comment on this. It has, I want to be clear, it has just nothing to do with capital adequacy, but it's a pretty intriguing question. The FDIC is set up in 1933 to provide a monopolized, government-issued, but still priced service, and that is insurance against failure for depositors. And that is supposed to be price sensitive in the sense that a really well-run bank is going to be paying less for its insurance, like a really healthy person will have to pay less for its life insurance versus a very unhealthy person who may not even be eligible for life insurance. In practice, it doesn't really function that way. And that's one of the reasons why FDI insurance premia, it is a regulatory process. I think it should be more of an actuarial one. It's kind of a hybrid version. This is one of the reasons why after SVB, people who had proposed insuring everything, no such thing as uninsured deposits anymore under these proposals, I despair at the thought because we don't have a really great success story to tell about the insurance actuarial process for this government monopoly.
I agree with all that.
Did you guys see that just now? Randy and I just completely agreed.
Wait, I agree too. I just want to say I've had the good fortune to really drill into how the FDIC goes about its business, setting assessment levels and the like. And again, I'm not a banking guy. I'm an administrative law lawyer. I've been very surprised at the weak analysis, the ipsit-dixit, the lack of substantiation that pervades in that area. And it's another area where if the FDIC gets aggressive and is taken to court, it will have problems because it does not jibe with how courts expect agencies to go about such significant decisions. Yep, question.
Thanks. I'm in this industry, familiar with it. Question for Mr. Conti Brown. I've been to several interesting and terrifying panels at the Federalist Society that discuss efforts to implement democratic industrial policy, particularly in the environmental field, through the banks. And we also saw some of this in 2008 with respect to encouraging home ownership for African Americans and minorities. Now, for both sides of the aisle, it's very easy to develop a list of favored industries or favored groups, including small business, either Republicans, Democrats. And then it's not difficult to come up with the risks, particularly that attach to either group of lists and which one a particular administration is going to favor. Now, you seem to suggest that this process, the term adequate capital and appropriate means to develop it, it's okay for that to be a completely political judgment. Is there any limiting principle that you see here? Because I think this, if that were to occur, I mean, it's just a tragedy in terms of what that does to the concept of independent credit analysis and the professional standards that are supposed to stand behind
Well, thank
this
you, and
industry.
Peter, you get
Thank
last word.
Great. I appreciate that question. It gives me a chance to clarify something. I have never said, and I do not think that these are completely political judgments. This is not something that Joe Biden from the Oval Office says, here shall be the capital standards. We saw something like that in March 2023, and I got to tell you, I hated it. I thought that March 2023 was not a fine moment in banking policy. I think it should have been much more technocratic in its exercise. No, my point is that these are value judgments at a frontier. And if we are not going to make those values selected electorally, then you have to have another epistemology to use to select them. And my question is, which will it be? If it's not technocratic, we all agree that there is a frontier where technocrats no longer have consensus. And my view is the Churchillian one. As far as the specific question about whether there are politically inflected questions about credit risks, there clearly are. And you can go hog wild on these kinds of things. I certainly don't like the idea of capital being constructed based on DEI policies. I've never heard that taken seriously on the left. But I think that that's a place where there are going to be questions. Climate change is going to be an important one. I think any bank supervisor looking at banks lending for mortgages in coastal Florida that does not look at the increased frequency of hurricanes is doing their job irresponsibly. But there should be an extraordinarily narrow band where those kinds of judgments would be exercised.
Well, please join me in thanking this fantastic panel. And I want to thank all of you in the audience or at home live streaming this. For more content like this, please check out regproject.org. That's regproject.org. Thank you.